Morning. We're back on the record in the 53rd Circuit Court for the County of Sheboygan. And again, we are providing public access both in the courtroom and also online. And up next, we have American Express National Bank v. Coughlin, file 25-9115CZ. Counsel, you want to state your appearances beginning with plaintiff?
Good morning, Your Honor. Michael Bengstein, P697778 on behalf of American Express National Bank.
Good morning.
Good morning, Your Honor. Leslie Honig, P71763 on behalf of the defendant, Charlene Coughlin.
All right, good morning. This is a motion for summary disposition filed by the plaintiff under C9 and C10. I reviewed the motion and the response. Mr. Bengstein, anything you want to say in support of your motion?
Nothing other than, defendant opened the account, made purchases and payments, and stopped paying on the account. Defendant has not demonstrated that there's any material issue of fact and dispute, and plaintiff is entitled to judgment.
Thank you, Ms. Honig.
Your Honor, I don't have much to add either, other than that there is an arbitration clause in the agreement with the original creditor, and I would request a stay for the purpose of starting an arbitration claim.
Okay, that was not in the original affirmative defenses, is that right?
That's a good question. I'm double checking that.
I thought I checked that.
I cannot remember, so I'm just pulling on my answer.
Yeah, I'm looking at it again, just double checking each of them. It doesn't look like it was. Okay. All right, Mr. Bengstein, your response?
Yes, as the court just pointed out, it was not part of the affirmative defenses. That defense has to be asserted in the first response to pleading, and that was not done. It doesn't appear that defendant is seeking to amend the answer to include that, and that's pretty late in the day to do that. Also, it has to be by motion. There is no motion to compel arbitration. And we have a motion for summary disposition up right now. There's really no, even if there was a motion to compel arbitration, there's really no dispute to be arbitrated. Again, we're entitled to judgment as a matter of law. I don't know what the arbitrators would do other than rack up more expenses for defendant and plaintiff.
All right, thank you. Plaintiff has asserted a breach of contract and account stated for an unpaid credit card debt. Defendant's answer asserted lack of knowledge as sort of a blanket defense. Plaintiff says they didn't truly engage with the claims, so summary disposition under C9 is appropriate. However, the answer did deny a lot of the claims. I think it's a bit of a stretch to say that it failed to state a defense. So I would deny the motion for summary disposition under C9. However, I would grant the motion for summary disposition pursuant to MCR 2.116C10. There being a showing by the plaintiff that there's no genuine issue of material fact and that they are entitled to judgment as a matter of law. The documentary evidence attached to the defendant's motion, to the plaintiff's motion, establishes the contract and the debt for both breach of contract and the account stated. Defendant has failed to counter with any documentary evidence that judgment should not enter, and defendant's assertion of an arbitration right is too late. It wasn't raised as an affirmative defense in the first response of pleading. Therefore, I would grant judgment against defendants in the amount of $25,453.60, reflecting the debt plus $245.70 in costs. And Mr. Bengstein, I see that there's a proposed order presented today. However, it did include a grant as to C9. So if you can submit an alternative order, either stipulated as to form or under the 7-day rule, denying as to C9 and granting as to C10.
My understanding, based on what you said, Your Honor, is that if we strike out the C9 language, that we can resubmit that proposed order to the court.
Yeah, actually, I could just add. It says it's hereby ordered that plaintiff's motion for summary disposition is granted, and I can put as to C10 only.
That's if the court wanted to do that sua sponte, that's fine.
Any objection to that, Ms. Honig, as to form?
No, Your Honor.
Okay.
And that's not, is this a my file court? Did you want me to resubmit that to you, or are you signing?
We are not a my file court, and we hope to be by the end of next year. But I've got a proposed written judgment in front of me, and I'm going to add that and initial that and sign it.
Thank
So
you,
we'll
Your
get
Honor.
copies out to folks.
Thank you. Have a happy holiday.
All right, thank you. You too. All right, there we go. And then we're going to move into the family division. So I'll terminate the live stream for the rest of the great. Good morning. And this is the defendant's motion to dismiss. I've reviewed the motion and then the response. Go ahead, Mr. Stein, with your motion, sir.
Thank you. This morning, Your Honor, we have a motion to dismiss up pursuant to MCR 2.202A1B. I know that's a mouthful. In any event, I believe that the issue has been well pled, in terms of our brief and our motion. And so I'm happy to take any questions that the court may have regarding its content.
Well, if you could maybe articulate, I know the case law doesn't require a showing of prejudice, but is there any prejudice to the late substitution or any possible prejudice you'd want to articulate on the record?
So, Your Honor, the only basis I think for prejudice in this event is that we are talking now 5 years after the date of loss. The accident occurred in the year, I think, 2020, and the case was filed a couple of days before the statute of limitations expired. And now, because of the delays caused with the death and then the proper substitution of the parties, we are now 5 years beyond that accident date, which of course makes it difficult to locate witnesses, recollections fade. And, so we would argue that just that pure, the elapse of time that goes by here is a sufficient prejudice to warrant dismissal.
Okay, thank you. Mr. Compton, plaintiff's response?
Yes, Judge. I mean, we'd rely on the response. Essentially, I think, as you indicated, the statute may not require it, but you're inquiring as to the prejudice. We don't believe that there is. We've been litigating the case. We've been dealing with this issue with getting the estate open, which we did. Honestly, I appeared before you at the last hearing, and that was taken care of. It seems as if the substitution just didn't go in, the changing of the actual party. But, I work with Mr. Stein a lot. I don't think that we're not going to be able to get it across the finish line, but I obviously think it would be extraordinarily prejudicial to us to have the case dismissed.
Well, let me ask you, I mean, when you said that this estate had been opened, we did then double check that and we're now past 91 days from the estate being open. So even if I were to excuse the 91-day period from the notice of death, why on earth have you not substituted in the estate when it's 91 days after the estate has been opened?
Yes, Judge, that's where I mean it, for lack of a better response, it seems like the meat of it is the getting the estate open. The simple part is the substitution of the estate. And I don't know I don't have an excuse for you, Judge. I really don't, other than, I mean, I remember arguing it. Me and Mr. Stein talked afterward. In fact, we were doing that last hearing and Mr. Stein was in the waiting room and he didn't get on the record. I mean, we had just spoke about it and I don't understand. I am not the lead counsel on it. I did appear at the hearing. That's why I'm here. But Ms. Shanta was informed of it. And apparently the substitution we didn't get the stip over. That's my understanding. And I don't really have I wish I could say more, but I mean, that's really the issue. It looks like we did get the probate stuff done. We just didn't get it substituted over.
Okay, all right, thank you. Any rebuttal argument, Mr. Stein?
No, I have nothing to add. Thank you.
All right, well, in this is a third-party auto negligence claim. There was an uninsured motorist and underinsured motorist claim against an insurer that is settled. And now we only have the third-party claim remaining. This case was, as of today, it's been open 782 days. It's the oldest case on my docket. The complaint was filed October 3rd of 2023, more than 2 years ago. The defendant, who was alleged to have been negligent in the motor vehicle accident, died in January of this year. Now, 11 months, almost 11 months ago, 10 months ago. A notice of the death was filed over 7 months ago. And as I said, it's been more than 91 days since the estate was opened. MCR 2.202 sub A1B provides that unless a motion for substitution is made within 91 days of the notice of death, the action must be dismissed as to the deceased party, unless the party seeking substitution shows that there would be no prejudice to any other party from allowing later substitution. And the Court of Appeals held in the Bradley case cited by defendant that even if no prejudice is shown, the court may exercise its discretion to dismiss the action. Here, the defense alleges that there may be some prejudice due to the passage of time in securing or the testimony of witnesses, because it's been 5 years since the accident. I'm not sure that there's a real strong showing of prejudice here. I mean, the defendant is a witness and she's passed away, but I presume her testimony has been preserved through some deposition. But there's no prejudice that would need to be required in order to dismiss it. The court rule says it must be dismissed unless there's a showing of no prejudice. And even then it's discretionary. Here, the plaintiff's response to the motion misses the mark, cites 2.313 as if this is a discovery sanction and urges the court not to impose the harsh remedy of dismissal as a discovery sanction because there's no bad faith or history of sanctions. And that entirely misses the mark. I'm just perplexed by plaintiff's counsel action in this case. As I said, it's my oldest case. It's 2 years old, 7 months since a notice of death. And even if I overlook that, even if I gave the grace of saying, once the estate was open, we're going to restart the 91 days, and we're past that with no reason whatsoever. It would have been either a STIP or not, or if it's not approved by a STIP, as is referenced in plaintiff's response, file a motion for substitution under the court rule. The plaintiff's response doesn't even cite the appropriate court rule. I think on the whole, given the length of time, the delay has been pretty dilatory here. I'm reluctant to do so, but I think it is a proper exercise of the court's discretion to grant the motion and dismiss this case. So, Mr. Stein, you can submit an order to that effect.
Yes, I will do that. Thank you.
Okay, thank you all. Have a good day.
Thank you, you too.
All right, up next, we've got Newell v. Cash, file 25-9152CZ, up for pretrial. Counsel, would you please state your appearances, beginning with plaintiff's counsel?
Good morning, Your Honor. Elliot Blumberg on behalf of Mr. Newell, who's appearing via Zoom from my office.
For Attorney David Greiza on behalf of the defendant.
Okay. Mr. Long, I know you're stepping in for Mr. Greiza today. I do want to mention at the pretrial conference back on October 27th, I advised Mr. Greiza that the appearance that we had for him, the substitution of attorney for him for Peck, was only as to the defendant Dusty Cash. The substitution by its terms was substituting for only one defendant. And Mr. Greiza appears to have failed to remedy that. Could you please put like stars and underlines and highlights? Technically, Emily Cash is still represented by Lyle Peck, who's not present. And that's the reason why I adjourned the pretrial last time. So how am I supposed to go forward with a hearing today with an attorney, with a party who, according to my court file and records, is represented by an attorney and that attorney is not present? Mr. Long, what say you?
I do not have an answer, Your Honor. I saw the appearance. It's my understanding that we only represent Dusty Cash, but again, I'm just stepping in for Attorney Greiza. So
okay, well, see, that's my assumption as well. But then Mr. Greiza told me, no, he intended to appear for both. So that's my problem today. So I guess, Mr. Blumberg, I hate to adjourn this again, but I mean, discovery, you're free to embark on discovery. Do you think we should go forward with a scheduling conference right now or no?
Well, I don't know, Mr. Long. I'm assuming he's in the same firm. I don't see why we can't at least conduct the pretrial, Judge. Again, I
Okay.
don't understand why this hadn't been remedied, but rather than coming back a month from now, maybe we can certainly move forward with at least a scheduling order.
Okay. All right, Mr. Long, would you please pass along to Mr. Gryza? I expect him to cure this within 14 days, or he's going to have a problem with me.
Will do, Your Honor.
All right. All right. Other than that appearance issue, Mr. Blumberg, are the pleading satisfactory?
I believe they are.
Mr. Long?
They are, yeah.
All right. Amendments would require leave of the court. Have the initial disclosures been served by all parties?
Yes, Judge, we just received the defendants. Well, and again, I don't know if it was just for Dusty Cash or whether it was for Emily, but initial disclosures have been filed by the plaintiff.
Okay. And how long do you want for discovery deadline, Mr. Blumberg?
Judge, I think 90 days at a minimum, and again, just because of the holidays, maybe 120, but I think 90 should be sufficient.
Okay, I'll do 120 just to give you that space. Witness list within 60 days, fine?
Yeah, that would be great.
All right. Do you want me to order this for mediation or just leave that up to you and the attorney to sort out?
I think the attorneys can probably try to resolve that. Thank you.
Okay. Mr. Long, is it okay if I don't order any formal ADR and just leave it to the attorneys to sort out if that's necessary?
Yes, that is acceptable.
Okay. All right. And is this is a non-jury matter, Mr. Blumberg, is that right?
Yes, Judge, it's kind of an equitable claim, so there is no jury entitlement.
Okay, estimated length of a bench trial?
I would say 2 days at the most.
Okay. And with it being a bench trial, I leave it up to the attorneys then. Do you want at the close of discovery a settlement conference with me in chambers, or would you prefer to do a final pretrial on the record?
A settlement conference is always a good thing, Judge, so I guess we would request that.
Okay, Mr. Long, any objection to that?
I agree with that settlement conference.
Okay, I just always double check with that when I'm the trier of fact. I just want to make sure counsel's comfortable with that, and then I leave it up to you what facts you want to share with me during that settlement conference. So let's see, 4 months out would be March. All right, so let's schedule this for a settlement conference on March 11th. At 11 a.m. All right. Anything else for purposes of scheduling, Mr. Blumberg?
No, Judge, thank you.
Mr. Long?
Nothing from me, Your Honor.
All right. Thank you very much. We'll get a settlement or we'll get a scheduling order out to counsel. And I did write on that defense counsel must file an appearance for both defendants within 14 days. All right. Have a great day, everyone.
Thanks, Judge. Happy Thanksgiving.
So you too.